So you know we're recording. Please don't say anything that will cause any of us to get sued. So good morning. We do not have Gary or John or Dennis with us this morning because they all had excuses, like they're out of town or they had medical appointments or some other lame excuse. But the good news is we have Carolyn Loving this morning as our host. So I want to take this moment to thank those guys, even though they're not online. But we could not be doing these Zoom classes without Gary, Dennis, and John, who got us started on that. And they have now expanded to include Carolyn Loving. So we're very appreciative of Carolyn joining the group. As I was saying to some folks as we were getting started, I focus on the teaching, and sometimes that takes all of my energies and focus, and then trying to deal with tech problems along with it would be just more than I can handle. A couple announcements, but before I do that, let me remind you of the quiz, and some of you have already weighed in. The quiz from last time is this: what percent of all cases, civil and criminal, federal or state, do you think actually go to a jury trial? So what percent of all cases do you think go to a jury trial? And we'll look at that in a moment. I sent some slides over the weekend. Those are the slides from last week as well as from today. Those will be the last that I send you. There are three references that you might want to record somewhere in those three slides. Let me rephrase that. There are some references in those three slides that you might want to record somewhere, because it would be useful. So if you are looking for an attorney or you know a friend who is, it would be helpful to have at hand the Illinois State Bar Association Lawyer Referral Service and the Illinois State Bar Association Directory, which gives you more information about lawyers. That's limited to people that belong to the Illinois State Bar Association. That's not all attorneys. For example, I don't belong to the Illinois State Bar Association. I used to, for years I did, but with retirement, I quit paying the dues, so I don't belong. So that's a very good reference to have at hand when people are searching for an attorney. The other reference when they're searching for an attorney is the Illinois ARDC, Attorney Registration and Disciplinary Commission. That is the body that I do belong to, I have to belong to. That's where I register my license every year. And that is the body that provides a handy check for you. So if you went on there and put in my name, you would find out that I am currently licensed, that I have never been disciplined, and that I do not have malpractice insurance. That's a very good thing to check, because you want to make sure that the attorney you're about to hire does have a license, is not been disciplined, because that could be a red flag of problems, and has malpractice insurance. I would not hire a lawyer who does not have malpractice insurance. I don't, because I'm not practicing, but if I were practicing, I would have it. So those are two handy references if someone's looking for an attorney. The other handy reference is the Illinois Supreme Court website, which has recently been redone and is really very nice. And if you go there and you check under, I think it's, well, I'm going to forget what it is. But if you go there and put in Illinois Constitution or U.S. Constitution, you can see the Illinois Constitution and the U.S. Constitution right there. They also have all the Illinois General Assembly statutes right on that website. So it's a handy place to go to find references. I dare say most of you have never looked at the Illinois State Constitution. And if you have a night when you can't sleep and you want to check it out, there it is. But it might be hard to find if you didn't know where to go. So keep that reference. You don't have to keep the slides, but write those three references down. A question from last time that I wanted to take up, and a correction from last time. Let me do the correction first. I got the 6th Amendment and the 7th Amendments to the U.S. Constitution confused, I think, last time. Both of them, and I'm talking U.S. Constitution now, U.S. Constitution, both of them refer to jury trials. The 6th Amendment gives you a right to a jury trial if you are accused of a crime. The Seventh Amendment to the U.S. Constitution gives you a right to a jury trial for a civil matter exceeding $20. So you can see that in 1789, $20 was a lot of money. If it's exceeding $20 and is a common law matter, you're assured of a jury trial if it's a civil matter. So I'll come back to that when I announce the results of our quiz. A question from last time that I did not get to is, if a lawyer is sent to prison, is that lawyer automatically disbarred? Does that lawyer lose his or her license? We call it being disbarred. And the answer is not necessarily. For example, suppose that a lawyer had a drinking or drug problem, and because of that committed a crime such as possession of drugs or a DUI, was sent to prison. I could imagine many cases in which the Illinois Supreme Court would not disbar that person, but instead would condition the license upon that person staying in counseling. So that person would probably be suspended for a period of time to see if he or she stays with the counseling program and any other advice as to how to handle his or her affairs. But at the end of that suspension period, they might reinstate the license conditioned upon continuing into counseling or rehabilitation. A similar question is, if you are a convicted felon, can you become a lawyer in Illinois? And the answer for Illinois is yes. It depends. I could imagine even a serious crime where someone killed his father, but he killed his father because the father was beating the mother. And even though he may have been convicted of assault or attempt or even murder and served the sentence, I could imagine that person becoming a lawyer. If a person had a history of dishonesty crimes, embezzlement, for example, I think that person would find it very hard to become a lawyer in Illinois. But a convicted felon could be a lawyer in Illinois, depending upon what that person's behavior has been since that crime. There are some states that would not allow a person who is a convicted felon from becoming a lawyer. So the two sides of that question. There's something in the news this morning that caught my attention that made me want to share this with you as well. You understand that licensing for lawyers is state by state. I have an Illinois license. I took the bar exam in Illinois. I also have a Missouri license. I did not take the bar exam in Missouri. Rather, in those days, we called it reciprocity. Now we have a fancier name for it. But if someone has been a lawyer for an extended period of time in another state with no disciplinary problems and a good record, he or she can become a lawyer in Illinois as well. But it does require that you go through some steps. Well, what about people who are married to, what about lawyers who are married to military? So the military frequently moves people around every 2 years. And a lawyer who's married to a military member of the military might not have acquired enough time in any given state because of the constant movement. Well, we have a rule, as do many states now, that allows a lawyer who is the spouse of a military member to become licensed in Illinois for the period of time that that military member is in Illinois. And because of Scott Air Force Base in Belleville, you could imagine people whose husband gets transferred, or wife gets transferred to Scott for 2 years, and that lawyer doesn't have time to take a bar exam. By the time they did that, they'd be transferred out. We're permitting those people to practice in Illinois for that 2-year period of time. I think many states have adopted that rule, not all have, but I know it's been very helpful to people whose spouses are at Scott as well as other military facilities in the state. Okay, so the quiz. Excuse me. So what percent of cases do you think go to trial? And we've got 10% or less, 5%, 8%, 3%, 30, 20, 41%. Well, depending upon which scholar you read, probably 2 to 5%. Most cases do not go to trial. I think it's safe to say it's in the 2 to 5% range, whether it's state court or federal court, civil or criminal. Well, why is that? And think about that for a moment. I just said to you that the 6th Amendment and 7th Amendments to the US Constitution guarantee you jury trial under most conditions. Why do we have so few? Well, partly because it's expensive and partly because it takes a lot of time. It's also emotionally draining, especially civil cases. And also because I think we've put some barriers into place that make it difficult for people to want to go through the process, but also because we've given people alternatives. So if you watch the movie Worth, you will see an alternative. Ken Feinberg was set up as an alternative to the civil trial system. I'm going to talk more about that in just a few minutes, but it's one of many alternatives. So I think that if you saw the movie Worth, there are 2 major questions that you can think about. One is, what is the process? What process was used? The other question is, and this is where the title comes from, what is the worth or value or cost of a human life? In that case, the people, primarily the victims, were dead, although many of them were also people who did not die in the attack, but died later of illnesses resulting from the attack. So what is the value of a human being? What is the worth? And that gets us back to the damages question we talked about the very first day. How do you figure out damages? In our car accident case, it was not a person who died, but it was a case of a person who was injured and may suffer future injuries or weaknesses as a result of that car accident injury. How do you determine the value of a life? What I would like to do is take the question of process first, and then we will end with the question of the value of life. While we're doing that, I want you to reflect on 2 questions. They're in the slides, but I'm going to show them to you here in a second. These were the questions that I put on the outline the very first week. This is a quote from Chief Justice Warren Burger in 1982. And at that time, there was a concern about the cost of the judicial system and getting cases through the trial system. And I just hit the wrong thing. He said that the obligation of our profession has been to heal human conflicts. And how should we do this? We should do it in the shortest amount of time with the least amount of expense and a minimum of stress. That, he said, is what justice is all about. Well, we're going to talk about some alternatives that are shorter in time, less expensive, less stressful. And then I'm going to ask you about the question of justice. The second quote I gave you comes from Owen Fisk, then a professor at Yale in 1984, and he said, adjudication, trial by jury, uses public resources, publicly selected judges, and juries selected through a public process, and employs not strangers, but public officials, as I just said, and their job is not to maximize the ends of the party, but to, listen to this quote, but to explicate and give force to the values embodied in authoritarian texts such as the Constitution and statutes. To explicate and give force to the values embodied in authoritarian texts such as the Constitution and the statutes, to interpret those values and bring a reality into accord with them. And he says, when you settle, you don't do this. And this is what he would say is justice. Well, two great philosophical questions for you to think about as we go through some of these alternative processes. So having just done the wrong thing, I'm going to go back and share again. So let's talk about some of these processes. So I'm going to talk about these alternatives to the civil jury trial: the workers' comp system, the various problem-solving courts and deferral programs, mediation, a very interesting creature of Illinois law called Illinois mandatory arbitration, summary jury trial, judicial or settlement conferences, special master, that's Ken Feinberg, and end with the multi-door courthouse before we turn back to what's the value of life. So those are the topics I'm going to be talking about, and I'm going to spend a few minutes on some of them and less time on others of them. The workers' compensation system, it's been around for a long time. How is it an alternative? Well, some time ago, the business community and the labor community came together and basically made a deal. The business community said, okay, we'll pay money into the workers' comp system. And the labor community said, okay, we won't sue employers when we get hurt on the job, but we need compensation. So they created a workers' comp system. So if I am hurt on the job, I don't sue my employer. I file a claim with the Workers' Comp Commission. And if it can be shown that indeed I was hurt on the job and I was hurt, then I get compensation. And the interesting thing, I'm going to go back to the slide for just a second. The interesting thing is that the workers' comp system tried to make things very easy because they put in all these calculations. So if you died or were permanently disabled or had a permanent partial disability because of a loss of a leg or of an eye, then here was it. They calculate this every week, but you would get something between $600 and $1,600 a week for the rest of your life. It's supposed to be 2/3 of your actual weekly wage. And these numbers that I just showed you, the 600 to 1,600, are set by some calculation of the prevailing wage in Illinois for that period of time. And you can go to the Illinois website and see this. If you go to the Illinois statutes governing workers' comp, you will see all kinds of matrices. So if you lost a little finger, here's the amount. If you lost an arm, here's the amount, and so on. It was meant to be fairly simple. And you can see we've reduced everything to dollars. Now, if you're a worker who's injured and can't work, it's good to have that money coming in so you can continue to have a place to live and eat and live and so on, because of the substitute for the workers' comp. So it was an alternative. I won't sue my employer in civil court. I'll go to workers' comp claim. The employer said, in exchange for not being sued, we'll pay money into it. That's basically how it works. Now, it's not always that simple. For example, suppose I'm a guard at Walmart and I see someone shoplifting, and I chase that person out of the store into the parking lot. Well, I was on the job, right? But I'm fine. I go home, and later that night, I have a heart attack. Was the heart attack because of the physical stress and the emotional stress of that chase? Or was it my heart, and it was going to happen regardless? That is an interesting question. Or I'm a employee at a bank. I'm a bank teller, not too much physically dangerous about that job, but the company, the bank, has an annual softball team, a picnic. And while I'm playing softball at the company picnic, I get injured. Was that on the job? So there are still questions, there are still issues that they have to get resolved, but it's much simpler. So the workers' comp system that's been around for a long time is an alternative, but it does not take into account some of those questions that Ken Feinberg had to take into account. Lately, we have been, so that's an old alternative. Here's a modern alternative, and that is problem-solving courts. So you may have heard in the news, and you may know that locally we have in Williamson County a problem-solving court. A person who winds up in trouble because of drugs or alcohol or mental health issues, or as a veteran, these are the three targeted audiences. And veterans, because many of the veterans have come back with issues related to PTSD or other issues that they wind up being very short-tempered, they may get angry easily, they may get into fights. Often what happens is folks who have these challenges wind up in the criminal court system, but inevitably, they also are having problems with their driver's license, with paying their rent. Maybe they've bounced a check or done some other similar kind of thing. Sometimes the problems are civil court, they owe money, sometimes they're criminal. What the problem-solving courts are doing is holding the criminal charges in abeyance, getting the person the help he or she needs. And then if after a period of time, and typically it's 2 years, could be longer, they have worked to resolve whatever those challenges were, or at least manage them, then the criminal charges go away. And in the process, they would try to get the civil issues of payment of rent or things of that sort resolved as well. They're designed to keep people out of jail and rather deal with whatever the problem is. It's very intensive. It's costly because of the amount of counseling, probation services, other personnel who are involved in this. Many of these require a weekly visit at the courthouse to check on progress. So it is intensive. It's costly in that regard, but it's a lot cheaper than $35,000 a year of feeding and clothing somebody in jail. And it's designed, obviously, to prevent future crimes by solving the problem. We have deferral programs, and I would call the problem-solving courts one example, but we, particularly at the juvenile level, we have deferral programs. Now, even though I told you this is a course about civil trials, some of these matters that I'm talking about now, problem-solving courts and deferral programs, go to criminal matters, but they fit under the category of alternatives, so I am going to talk about them. So particularly at the juvenile level, we try to, as much as possible, to defer kids out of the criminal justice system and deal with the issues that they're having at home, at school, whatever it might be. And one of those types of programs are you sometimes see the word restorative justice programs. Restorative justice programs, the idea is, I'm not going to send this kid to county jail and have him sit for 20 days and eat on the state. Rather, I'm going to try to get them to restore some justice to the person they harmed. So if they shoplifted, then maybe we're going to send them back to the store every Saturday to clean up the outside or wash the windows or do something of that sort. Or maybe the store owner says, I never want to see this kid again, but here's what I do want. I want that kid to go to the park and clean up the park, or I want that kid back in school, or things of that sort. So the restorative justice programs bring the offender together with the victim. Sometimes they're called victim offender reconciliation programs, and try to get the kid to recognize, and I say kid because a lot of these are aimed at juveniles, get the offender to recognize that there was a harm, that society is harmed as well as the victim is harmed, and try to get them to restore the program in some way. Union County below us, has led the way in our area of getting funds from the state to do these restorative justice programs for youth, and many of the counties, including I think Jackson and Williamson, both participate to some extent in these programs aimed at youth. So another alternative aimed more at the criminal system. Let me move now to more alternatives aimed at the civil system. And the first one I want to talk about is mediation. I talked about mediation earlier in response to a question, but I'm going to repeat in case you missed it. And I'm going to repeat because it's the field that I worked in, so I'm going to repeat because I like it. So mediation is a process for resolving disputes that brings people together with the help of a mediator, literally, think medium, someone who sits in the middle between the parties and helps them resolve the conflict. The critical question between mediation and arbitration boils down to two words: who decides? In a mediation program, the parties decide. In arbitration, the arbitrator decides. A decision is imposed upon you. Mediation, bring the parties together. You talk about the past, but only for so long, and you don't try to figure out who's right, who's wrong, who's guilty, who's not guilty. Instead, you try to say, all right, that's the past. What do you want the future to be? I used to mediate family cases, mom and dad. I didn't ask them to trust each other. They're getting divorced. There's not a lot of trust. There might be a lot of anger and a lot of hate. What I did ask them to do is, for the next 10, 20, 10, 15, however many years that you're going to parent these kids, how do you want it to be? Do you want the kids dreading Friday night when they move from one house to another because they think you're going to get into an argument? Do you want to be able to attend grade school graduation, soccer games, high school graduation, the kid's wedding sometime in the future, and not have everyone worried that there's going to be a big to-do when both of you are in the same facility at the same time? Then how can you work out a civil manner of being parents? I'm not asking you to trust each other. I'm asking you to figure out, how will this work so that you're not upset every week, the kids aren't upset every week, and you manage this. In 1993, when I came to SIU, I headed up our ADR clinic, Alternative Dispute Clinic, Alternative Dispute Resolution Clinic, ADR, primarily mediation. And at that time, the judges in our area were wanting to use mediation in family court because they believed that the parents better know how to parent the court than the judge knows how to parent the kids. And they were in the process of working this out. The Alternative Dispute Resolution Clinic that I headed and others on the faculty here worked closely with the judges to get the program up and running. We had to do all kinds of rules, and my poor secretary at the time had to type rules and then retype them and edit them and then make more edits as we worked out the rules of that. Today, it is routine. It is just routine. People that are going to get a divorce or enter into some kind of a parenting agreement regarding their kids in this circuit, the First Circuit, know they're going to be in mediation. Because the court wanted to require mediation, you have to deal with, well, what about the folks who can't afford it? Because mediators charge money. It's a private service. It's not a public service, it's a private service. So a number of the faculty here at the law school agreed that they would become pro bono mediators. That is, we mediated family law cases at no cost to the people if the court told us this is a couple that cannot afford mediation, and would you please mediate for them? Mediation is used in other cases than a family. It is widely used in our area for a case like this car accident. It is widely used in our area for civil matters, whether they're a serious malpractice case where there is a lot of money involved, whether they're a case such as this car accident where there is a lot less money involved. When we were talking about damages in this civil case during weeks 1 and 2, someone asked me, would you really bring this case to trial? It's not that much money. Well, in our area, yes. In our area, I think you could afford to bring this case to trial, but even better, mediation. And mediation could be used before the case is ever filed, or it could be used after the case is filed in circuit court, but before you've spent the expense of getting ready for trial. So mediation is widely used in our area now. SIU no longer has an alternative dispute resolution clinic. It's one of those things that happens when you have to do budget cuts, and there were other factors involved as well. But there is a mediation program here that I want to take a moment and tell you about. I'm going to share the screen again. There is a program called Dispute Resolution, Inc., DRI. It's located along Route 13 between Carbondale and Murfreesboro. It serves much of Southern Illinois. It offers mediation services for family disputes, for civil disputes for a fee. It offers mediation program for through the United States Department of Agriculture for disputes between producers, farmers, ranchers, and the USDA. And here's something I want you to know about. It offers a limited mediation service for nonprofits. So every once in a while, I get a phone call saying, I'm with such and such agency, we're a not-for-profit, we're a small group, but we're having disputes among our board members. Or we're having a conflict between our board members and our manager. And we don't want to fire our manager, but we want to resolve these disputes. Well, I used to do that for free. I'm retired. I don't do that for free anymore. And the ADR clinic does not exist. But this Dispute Resolution, Inc. is an outgrowth of our ADR clinic. It's gone private. It's a non-for-profit, quite legitimate service. And it will offer a limited mediation service for nonprofits. So if there's that kind of dispute among the board or among employees, and you just want to get people talking to each other again, there's a limited mediation service. When I say limited, cost would either be free or minimal for a short period of time to help out not-for-profits. Right now, it's offering an eviction mediation service to the courts. So you may have heard on television the last few days that the Illinois Supreme Court, along with the governor's office and the federal money that's come into the state, is offering this program. If there is an eviction matter in front of the court, if the landlord and the tenant who owes money work together, and if the reason the money is owed is related to COVID, then the landlord can get 12 months back rent and 3 months future rent at no cost to the tenant, but they have to work together and it has to be related to COVID. And one of the ways to get them talking to each other and getting things worked out is through a mediation program that DRI is running. So again, another alternative to the dispute resolution system. They could be in state court and in landlord-tenant court, eviction court, and the tenant could be evicted, and that would be the end of the story. The landlord would get no money. The tenant would have no place to live and would have an eviction on the record. This is a nice alternative. If you know people in this situation, or you know people who know people in this situation, please tell them when they get that eviction notice from the courthouse, they get a summons saying, come because the landlord wants to evict you. There's a sheet enclosed that says, here's an alternative. Have them read it. Oftentimes, people in that situation just don't show up in court because they figure they're already losing. No sense losing anymore. No sense going to court and being humiliated. They just don't show. Please encourage them to respond. I think there's a phone number or something they need to respond to. They can get 12 months back rent and 3 months future rent paid. They can keep an eviction off their record, but they're going to have to show that it was COVID related, and they're going to have to show up and work with the landlord. Let me pause there and see if there are any questions before I proceed to confuse you with the next program that's going to be a little confusing, mainly because of what it's called, not because of the program. So any questions about mediation or these problem-solving courts or the workers' comp system? And you can put those in chat. And I will look at chat here for a moment and see if there's any questions coming in. And while I'm waiting to see if there's questions, let me say, mediation is not the cure-all. If somebody is a racist bigot coming into mediation, they're probably going to be a racist mediation going out of mediation. It's not going to solve them. If someone has serious anger management problems or mental health issues coming in, they're going to have those going out. So there have been cases where I simply stopped mediation because we could not get it resolved. But for many people, most of the time, it's a very good program. So is DRI unique to our area or is it a national company? No, it is unique to our area. It is a not-for-profit that was formed by people who used to assist with the Alternative Dispute Resolution Clinic. So when I worked here under in the Alternative Dispute Resolution Program, the ADR Clinic, my boss and some of the others who were the pro bono mediators decided that when the law school ended the program, that it would be a good idea to keep a program. So they formed a not-for-profit. They have a board of directors. They work with the courts. They are unique to our area. Nationally, there are programs, some for profit, some not for profit, all over the country that do this and do it on a much bigger scale than DRI does. But we should be very appreciative of the fact that these folks, some of my friends, have formed this not-for-profit. I did not join them just because I said I'm retiring. And I know how it is. You say, well, I'll just sort of help out. Well, I'll go to this meeting. Well, I'll just do this one project. Before you know it, you're working full time. So I refuse to participate. I donate every year to them. And I do some training for them on occasion. But I decided it was best if I not get too involved because it's hard to be a little bit involved in programs like that. So I decided not to. Who pays for the mediation for the eviction cases? The state does. It's part of the federal money that's coming to the state for as part of the COVID relief program. If the criminal problem is caused by mental illness, how is it solved? Well, it's solved through counseling and therapy. Sometimes it can't be solved, right? Sometimes it just can't be solved. The person's not going to they're going to need counseling for the rest of their lives. They just can't manage to live in society. Those charges are not going to go away. But generally, it's a matter of counseling, therapy, but it's a program that gets people into the mental health system that they might not get into otherwise. And you frequently hear on the news that there are there's a wait period. I was trying to find the right word. There's a wait period to get in. So I have a drug problem. I know I have a drug problem. I want to get into a residential program. And I go knock on their door and they say, come back in 6 months because we have a wait list. Well, if you're part of this problem solving court, you move to the top of that wait list. So it's not a cure-all. Again, it's not a cure-all, but it does get people to stop the downward spiral, figure out what the problems are and try to get help. Under workers' comp, are medical expenses paid? Yes. Is there a limit to the amount paid? I don't know. I assume, but I don't know. Okay, those are all the questions. All right. Then let me talk about mandatory arbitration. Our car accident case is a perfect example of why Illinois created a mandatory arbitration program. So back in the mid-80s, the mid-1980s, the Illinois Supreme Court looked around and said, you know, we've got these cases, whether it's a car accident case, maybe it's a small construction case, the dollars aren't a whole lot, but they're just not moving. They're sitting in the courthouse. The attorneys are not taking them to trial. They're not getting them ready. They're just sitting, and people need resolution. And we need the calendar cleared. What can we do? And it created something called the Illinois Mandatory Arbitration Program. The reason it's confusing, I'll get to in a minute, it has to do with the words, not with the process. But here's how it works. In selected counties throughout the state of Illinois, mainly the larger counties, if you filed a lawsuit such as the one we have here, $30,000 worth of damages at the courthouse, the court would say, take this case to mandatory arbitration. You don't have a choice. It's mandatory. And what would happen is you would move from the court docket to the arbitration docket, and you would be assured a hearing date in front of arbitrators within 365 days. Now, how do you get a case ready in 365 days? And let me tell you, I've talked with the judges here, when we're not in pandemic mode, you could get a case such as our car accident case to trial in 18 months, maybe 24 months. The biggest issue that, sorry, I lost you there for a minute. I had to click something. The biggest issue with regard to getting a case to trial in our area is not the attorneys, but the doctors. And it's not the doctor's willingness, it's the doctor's cost. So if I'm going to try this case where you were injured, I've got to have a doctor come in and take the stand and testify as to your injuries and that they were caused by this car accident, except no doctor's going to do that. So we're going to take the doctor's deposition at the doctor's office at the doctor's convenience and then read it or play it to the jury at the trial. Well, to do that, we have to pay the doctor. And the fees that the doctors are charging are getting pretty expensive. And therefore, lawyers want to defer the cost of taking that deposition as long as possible. So if the lawyers think the case is going to settle, they don't take the doctor's step. They keep waiting and waiting and waiting until the other side gives in and gets it settled. Well, what if we had a program where you didn't need the doctor's deposition? What if we had a program where within 365 days, you would get a hearing in front of a panel of 3 arbitrators, and those arbitrators, or the rules of this would be relaxed in terms of the evidence. So if I submitted evidence to the other side, to the insurance company, and the insurance company's lawyer, prior to the hearing, and if the other side did not object, that's going to go in. I don't have to bring the doctor in. So I could get a 3-page report from the doctor, which is going to cost me a lot less than a deposition. And it's probably going to say everything we need to know. I saw this person on the state. They told me they had an accident. I looked at their injuries. Here's what they are. They never had this problem before. It's my medical opinion that the injuries were caused by the car accident. Here are the costs related to that. That 3-page report, maybe 5-page, could go into trial without the need for the doctor. We can have witnesses, but we can also bring in, remember that car accident, that body shop estimate I told you about the first day? Remember how I told you that a body shop estimate is only hearsay? That if we want to know what the body shop mechanic thinks has to be done, we bring that person into trial and we subject that person to cross-examination. We find out that he's my brother-in-law. Well, that's why it's going to cost so much. Well, under this mandatory arbitration program, the estimate would come in as evidence if I gave it to the other side 30 days in advance of the hearing. Who are these arbitrators? Well, they're attorneys from the community where these programs exist who go through a training period. They have to recuse themselves if they know the parties have a close personal relationship or business relationship with the parties or with the subject of the lawsuit. The hearings take place in an hour and a half, 2 hours. The arbitrators then make a decision. It could be a 3-0 or a 2-1 decision. They send it out, and then you have 30 days to accept or reject it. So let me go over that. Remember, I told you mediation, arbitration. Mediation, who decides? The parties. Arbitration, somebody else. This program's mandatory. You have to go. But wait a minute, what about my right to a jury trial? That's why you get a chance to reject. So you have to go. If your case fits the category, you have to go to arbitration. You have to appear and put on a trial in good faith. 2-hour trial, minimum amount of work, minimum amount of cost. You will get a decision, but the decision is not mandatory. Going to arbitration is mandatory. The decision is not mandatory. You have a chance to reject the decision. And then if you reject it, you go to trial as though it were brought to the courthouse to begin with. That has resolved much of the backlog of cases like our car accident case, which in some jurisdiction just sat and didn't move because the attorneys, maybe because the attorneys were not good attorneys, but often because of the cost. They did not want to incur the cost if they thought it could be settled. This has done wonders for moving cases. It is saving judges time. In one county, they were able to move a judge from full-time handling cases like this to 3/4 time handling the criminal docket and 1/4 time overseeing cases like this. So I was asked a question, who decides whether the arbitrators are competent? Well, it's 2 ways. One way is they have to go to this training. The other way is if you really get 2 bad arbitrators and you don't like their decision, you reject it. So remember, it's mandatory to go, not mandatory to accept the decision. You can reject the decision in 30 days. Do you know how many cases in this program wind up going to trial? 2%. 2%. So in many cases, the arbitrator's decision is accepted, but in more cases it's rejected, and then the attorneys use that decision as a guide to settle the case. So mandatory to go to arbitration, not mandatory to accept the decision. Most decisions either are accepted or are used as a guide to getting the case settled. 2% go to trial. Now, I have to say that this is a wonderful program for Illinois. Illinois was not the creator of the program. Illinois recognized that it had a problem, and it sent judges around the country to look at other programs. It liked what was going on in Florida, and it built a program around what was going on in Florida. So kudos to the Illinois Supreme Court for recognizing an issue and trying to resolve it, and looking around at programs that worked. Where is it? Well, it's in Cook County. It's in most of the collar counties around Cook County. It's in St. Clair County, which is Belleville, Madison County, which is Collinsville, Edwardsville area. It's in Rock Island area. It's in Rockford. In fact, Rockford was the original pilot program. And it's in the Bloomington area. Why it is not in Springfield, I don't know, because Springfield is one of those larger counties that would benefit from it, but for whatever reason, it is not caught on. Initially, the attorneys were very leery of it. So the attorneys said, and many attorneys in Illinois tend to either do plaintiff's work or defense work. So they either represent you, the person that got hurt in this accident, or they represent the person hired by the insurance company to represent the driver who hurt you. So the plaintiff's attorney said, boy, you know what's going to happen? those defense attorneys are going to all volunteer for this program as arbitrators, and we're going to get bad decisions. And the defense attorney said, you know what's going to happen? Those plaintiffs' attorneys are all going to volunteer for this program, and we're going to get bad decisions. So it worked out. It's worked out that I don't know that the panel of three is always evenly matched, but it's worked out that the attorneys tend to render decisions that they think a jury is likely to give, that is reasonable under the damages. Someone asked me, can you volunteer for this program? No, you'd have to fit the court's criteria of being a case under, in most counties, it's under $50,000 worth of damages. But you can volunteer for what I'm going to talk about in just a second. So mandatory arbitration. Now let's talk about regular arbitration, because mandatory arbitration is by Illinois state legislation and Illinois Supreme Court rules. So the legislature and the court created this program. No one chose to enter it. You're required to enter it. Now let me tell you about arbitration, which in its purest form, you contract for, you agree to. So I'm going to take you back 50 years. So maybe even farther back than that. Let's talk about arbitration during World War I and II. So during World War I and II, it was essential that our industries keep working. We need planes, we need parachutes, we need ammunition, we need guns, we need ships, we need whatever it is we need boots. So unions don't strike, you got to keep working. And the union said, and again, I'm dumbing down these negotiations, but this is the essence of what was discussed. The union said, well, if you impose rules during the war that we can't strike, then that means the industrial leaders are just going to have oppressive work conditions and there's nothing we can do about it. So the parties agreed, with the help of political leaders, to use arbitration to resolve labor and management issues. So we got to keep making these boots in this boot factory for the troops, but conditions are bad. Okay, we'll take that to arbitration, but we'll keep working. I was entitled to pay increase and I didn't get it. Okay, we'll take that to arbitration, but we're going to keep working. So the idea was that the parties, labor and management, chose arbitration, and they would choose as their arbitrators people who knew the industry. So painters chose people who know something about painting. Steelworkers chose somebody who knew something about conditions in steelworking facilities, and so on. That is pure arbitration. It is chosen by the parties. They agree to live with the result. So not only do they choose to go to arbitration, they choose to accept the result. Now the result has become mandatory. The choice to arbitrate was voluntary, and they have control over who their arbitrator is. It was widely used in the construction field. As I mentioned before, you build a building and there's something wrong. Think of all the people that could be guilty, could be liable for what went wrong. It could be the site manager. It could be the engineer who tested the soil. It could be the architect who designed it. It could be a general contractor. It could be any of the subcontractors. Everybody's going to be pointing the finger at the other guy. So early on, arbitration became a matter of choice in construction contracts. So the parties would agree from the beginning, if there's a dispute, we will use arbitration. Or arbitrators will be people that know something about the construction field and understand the terms that we're using. And we will agree to live by the results. And in exchange, we agree not to go to court and not to sue each other. That was voluntary arbitration. They wrote it into their contracts. They agreed to it early on. The benefit is they got arbitrators who knew the field. Question came up either in week 1 or week 2. Can juries understand all this stuff? And are there some matters that are so complicated that juries can't understand it? That's a perfect place for arbitration because you can choose your arbitrator. So in a highly technical field, you choose as your arbitrators people who know the technology. It's used in international shipping. It's used in international commercial agreements. We want as our arbitrators people who know the field. So again, pure arbitration. It's voluntary, you choose it. You write it into your contract. It's mandatory because you agree in advance that you're going to live with the decision. You see why the terms get confused? The Illinois mandatory program, it's mandatory to go, but not mandatory to accept it. In pure arbitration, which I just talked about, it's not mandatory, you choose it. Now it's become mandatory because you chose it, but the decision is mandatory because you entered into it. That's pure arbitration. I think it works beautifully in fields such as construction, highly technical fields. It works beautifully in labor management. And one of the reasons it does is because you have sophisticated parties on both sides. So when labor and management decide to arbitrate, they both know the arbitrators. There's a group of people that regularly arbitrate steelworker disputes. Union and management have people who are sophisticated enough to look at the arbitration roster and choose arbitrators that they think will work. Technological field. They again can look at arbitrators who are experts in that field, get a roster of people, and choose somebody that both sides are willing to live with. That's pure arbitration. Well, along about 1980, and I will tell you right now, I have a very strong bias here, and I don't know how to hide my bias, so I'm not going to. Around 1980s, some of the commercial enterprises said, that sounds like a pretty good deal. Let's start putting arbitration clauses in our contracts. So every one of us on this call right now have entered into agreements to arbitrate our insurance disputes, our credit card disputes, our disputes with Verizon, or AT&T, or DirecTV, our disputes with Blockbuster Video, if they still exist, et cetera, et cetera. And I know that neither of us ever sat down and entered into a negotiation. It's become part of the fine print. So if you have a dispute with AT&T, DirecTV, you name it, you've agreed to arbitrate. You agreed to arbitrate when you either signed on the dotted line or you accepted the product. When you ordered the Dell computer that arrived in the big box on your front lawn and you brought it in the house, which you ordered over the phone or online, and you never saw a contract ever when you ordered it. Now you bring that computer into the house and you plug it in and you take that manual and you take that paperwork that came with it and you put it aside and you never look at it. Well, you agreed to use it because somewhere in that contract it says use of this product constitutes agreement to the following terms, and then the terms are listed there. When you got your credit card and you went online and you found this great credit card because it gave you 0% interest for 175 days and free rooms at the Hyatt. I'm making that up, but you get the idea of the kind of advertising that they give you. So you chose that credit card. And of course, when you chose it online, you didn't get the contract. The contract comes after the fact in the mail, that fine little print, which you've never read, and maybe you actually kept and put in a file somewhere. Well, the U.S. Supreme Court has said that's okay. It's okay to put a dispute resolution clause in the fine print of the contract that you get, because it's no different than any other term in that contract. Well, I say to the U.S. Supreme Court, what about this, sorry about that this morning. What about this Sixth Amendment right to a jury trial in a civil dispute? And the U.S. Supreme Court has said, wrongly, I think, but they have said it, and it's the law. Well, you've simply moved the dispute from the courthouse to the arbitration room. That's okay. You still have a right to have a dispute being resolved, and you chose to have it resolved through that way. I can go on for an hour for the various reasons I think it's wrong, but that will be an hour of my time and your time wasted because the U.S. Supreme Court disagrees.
Do you have any
also
choice of
find-
arbitrator?
I'm sorry?
Do you have any choice of your own arbitrator
Well, yes and no.
or input? Yeah.
Yes and no. So if you are lucky, DirecTV, AT&T, whomever, I'm not picking on them, it's true of all of them, has said arbitration will be conducted in accord with the American Arbitration Association rules. If that's true, you got a pretty good deal. The American Arbitration Association is a not-for-profit entity that has been around since 1925. It was created to resolve those early business disputes. And it tries to be fair. It wanted business. It wanted you to come back. It wanted both sides to come back. So it tended to be very fair. And it created some procedures so that each side could get some limited discovery about the dispute in advance. And it was pretty good. And it would give you a roster of arbitrators, and you could go through that roster and you could say, I don't want Jane, she's biased. I don't want Tim, he's too dumb. And each side would strike off names until you got down to one name or three names, and that would be your arbitrator or your panel of three or your panel of five. You could decide that. As we moved into this area where arbitration started to be used in consumer agreements, AAA, American Arbitration Association, said, we're going to create some rules about how we handle these consumer matters. And it's going to be less costly than regular arbitration. And we're going to make it simpler. And we're going to assure some degree of fairness. If it is not an American association, if the clause that you're dealing with, so pull out your insurance policy, pull out your credit card agreement. And if it does not say American Arbitration Association, it might say anything, and it could be anybody, in which case you don't know what you're getting. It's part of the reason I think it's unfair. One of the many reasons I think it's unfair. Today, you will find these in employment contracts. My favorite case, and I know I'm dwelling on this, but this is how badly I think this program, the law has become in this area. So imagine a 16-year-old boy or girl goes to, you name your favorite franchise restaurant, Outback, Applebee's, Chili's, Hooters, Buffalo Wings. I don't know that those all have this program, but many of them do. And on day one, they are filling out all those various things that you do on day one, your tax form, where you want your check sent, all that sort of thing. And by the way, they've signed an agreement that if they have a dispute with their employer, they will arbitrate it. Well, Hooters had such a program. And Hooters made this program as one-sided as it could. So the only people who would be arbitrators would be people Hooters would choose. Guess how fair an arbitrator is going to be that Hooters chose. And they had all kinds of other requirements that gave Hooters a distinct advantage over this young 16, 17-year-old, 18, 19-year-old who signed that agreement. Now, maybe if it was a 16 or 17-year-old, you could say you could void it because they were a minor, but an 18, 19-year-old who's still pretty unsophisticated and just wants some money signed that agreement. And then when conditions at work were bad and they tried to sue, Hooters said, no, 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 you signed an agreement. Well, I'm happy to tell you, and I'm so happy that it was Hooters that this happened. The court said, enough is enough. You've made this so one-sided, it's unfair, and they threw out the whole thing. So there is the possibility that some of these agreements to arbitrate that we agree to by choosing to use the product, by purchasing the product over line, by accepting the terms online, if they're so unfair, they could be thrown out. Another area where this has become standard is in nursing homes. So mom or dad gets to the point where he or she can't be cared for at home. You're going to take your loved one to a nursing home or some similar kind of facility, residential facility. And again, you sign all those forms that first day. It wasn't that long ago that I had power of attorney over my aunt and had to sign the paperwork, the documentation to admit her to a nursing home. She was going in with hospice. We knew her time on this earth was limited to a week or two. Nevertheless, I had to reject a pneumonia shot. I had to fill out all kinds of information about her life history and what she might enjoy doing in a nursing home, even though we knew she was not going to enjoy anything in the nursing home. She was going to be on pretty high dosage pain medicine. I think there were 18 or 20 sheets of paper I had to sign to admit her to the nursing home. Well, somewhere in there might very well have been an agreement that if I had a dispute with the nursing home, I would take it to arbitration. There have been an argument that that just ought not to be. We lawyers call it unconscionable. It is unconscionable that you would make a decision in that situation like that, an extreme situation. What's the choice? I'm going to take mom and dad home and not admit him or her to the nursing home because you've got this dispute resolution clause in here? It's unlikely. Nevertheless, so far, that is the law. So, arbitration in its pure form, sophisticated parties on both sides, labor and management, business, construction contracts, construction contractors who understand each other and understand the process, business people who understand each other and understand the process, come together, willingly choose arbitration, choose their arbitrator, choose to live with the award by the arbitrators. I think that's fine. I think it's great. It got us through 2 world wars. But arbitration in the commercial field, the consumer field, and in the healthcare field, and in the employment field, I think is wrong. But as I said, I could argue that for another hour and it will still be the law. So you've all agreed to it. Just be aware of what it is. Questions about arbitration? Again, I think I'm not a naysayer for arbitration. I am a naysayer for the way in which arbitration is being used in some circumstances. Well, arbitration can exist totally outside the field of the court. So you would never see the courthouse because you've chosen from the beginning to use arbitration. I'm going to talk in just a minute about one that is court related, but the question is, what about SIU? And I'm not sure what that means. So can you help me out?
Yeah, did they have, sorry, it's easier to ask it in person. I worked for them for 10 years and I'm not sure, you know, because we had a strike when I first started working there. But do you happen to know, I mean, you worked for SIU also. Is there a condition about suing SIU, taking them to court for something, or do you have to go to arbitration? Do you know?
Okay, good question. Thank you for that. The Hooters example I gave you is a situation where there's no union. SIU, there's a union, several unions. Where the union has made the decision for you, if you're an employee who belongs to the union or is governed by the union contract in some way, the union makes that decision for you. In that case, I don't think it's so bad because, again, the union is the person who's going to work with management to find arbitrators who ought to be fair and competent, as opposed to Hooters, where the 19-year-old is going to have no clue how to find an arbitrator who's fair and competent. So in a case where there's a union, the union will decide for you for arbitration. You don't have a lot of choice over it, but at the end, you have a more sophisticated party in a better position to decide the rules, the process, who the arbitrators are. So that's how arbitration works in a context like SIU where there's a union. Same for firefighters, police officers, steel workers, AFSCME, any Teamsters. I'm not working from home, and I don't know if there's something in this room that I'm working in that's giving me some congestion today, or if it's the change of seasons, or if it's something else. But sorry about my voice. I'm having trouble with it.
It sounds like arbitration is what was needed in that trial I talked to you about when you talked about patents.
Yeah, I think it was.
Yeah, because Motorola was known so well by the very untechnical jury, and nobody had ever heard of the little patent company.
Yeah, I think when you have something that technical, arbitration is a good choice. But there, again, the attorneys, you have attorneys, and they can help to frame the rules, choose the arbitrator. The 19-year-old at Hooters has no clue.
Yeah, because the jury trial was a fiasco because the jury had not a clue.
And again, you know, that's what I'm saying. In technical fields, pure arbitration, I think it's a good choice. All right, let me move on to go back to a court-related setting. So we filed our civil lawsuit at the courthouse from the car accident. One thing that might happen, probably would not happen in a case with dollars like this, but let's pretend for a moment it's big dollars. Let's pretend it's a major medical malpractice case where we're talking millions of dollars at stake. The parties might choose what's called a summary jury trial. The court would say, attorneys, prepare your case in 2-3 hours. You're not going to bring in witnesses, or maybe you could bring in one witness. We're going to bring in a jury, maybe 6, maybe abbreviated. And in one day, each side is going to tell the jury, probably by speaking, closing argument kind of situation, maybe by a witness or two. But we're going to do it in narrative form, not a Q&A as on trial. And we're just going to give the jury the essence of the case. And then the jury is going to adjourn to their room, and they're going to discuss the case, and they're going to come back and give us a verdict. The verdict is not binding. It's not mandatory. but it's a good idea of what a jury might decide in a case like this. So summary meaning abbreviated, jury trial, jury because we're going to bring a jury in. It can take any number of variations on that theme. It's presided over by a judge, but imagine that in half a day, 3/4 day, a judge overseeing an abbreviated trial can give the attorneys and the parties a good idea of what a jury chosen at random is likely to think the case is worth. And then the hope is that the parties will settle. I don't want to go much farther than that because it could take as many variations as you can imagine, but it is very helpful when the parties are far apart in their view of the case. Settlement conferences. I mentioned to you on day 1 and 2 that Illinois Supreme Court has a rule that says the judge must have a settlement conference, must bring the parties together, and must try to resolve it. And when I say parties, I should not have said the actual parties. I should have said the attorneys. Sometimes the parties will be there, sometimes it will be just the attorneys. And the judge will try to get them to settle. In federal court, they frequently use these and do bring the parties, the actual plaintiff and defendant together and try to resolve it. I'll give you one story. There was a prisoner in one of our local county jails who got hurt. And he said that he got hurt because the guard slammed the door shut when his hand was in the way and it hurt him. And he thought they did it on purpose. Well, he files a federal lawsuit that his rights have been violated. He's being punished by being harmed and he's injured. Well, his medical care is paid for by the federal system because he's in prison. He's entitled to medical care. But nevertheless, he's hurt. And more importantly, he's mad. So he files this federal lawsuit. The judge brings together the prisoner's attorney, the guards from the county attorney, tries to settle the case. And uses a form of mediation where the judge goes from room to room. So he has them together for a while, he separates them, and he goes from room to room. And he says to the prisoner, what do you want? What is it that motivated you to file this? And the prisoner says, I'm mad. And I just want a chance to sit across the table from these guards and tell them how they've hurt me and how mad I am. Money? No. My medical care has been taken care of. I want to talk to them. Judge goes to the guards and says, this case can go away right now. No money if you're willing to sit and listen. You don't have to like what he says. You don't have to approve of it. You just need to sit and listen. Are you willing to do that? And half an hour or so later, they're in the room together. The prisoner has his say. The guards sit and listen. They don't agree or disagree, but they don't smirk. At the end of which, judge says to the prisoner, can we dismiss the case now? Yes, we can. Case is over. Very simple example. Now imagine that a settlement conference could go on for 2 days with many parties and many attorneys, but the same kind of thing back and forth with the judge. Or in some cases, they will have special judges who only do this and then don't try the case. So if the case does not resolve through federal settlement conference or state settlement conference and it's going to trial, you'll get a different judge. Widely used throughout the state of Illinois. Let me rephrase that. The state of Illinois has rules that allow it to be widely used. It will probably vary with the judges in any given county as to whether it's used or not, but it's available. That brings us to special masters. There's no reason the state court could not use a special master, but it's used more by the federal courts. And that brings us to Ken Feinberg. So prior to 9/11, there were at least two major cases where Feinberg was involved. One involved asbestos and the other I'm blanking on. But it was a major, major kind of situation where people said that they were exposed to, I think it was Agent Orange. So vets said they were exposed to Agent Orange and were injured. People, workers said they were exposed to asbestos on the job and they were injured and they were suffering, and they wanted some recompense. And these are thousands of people. Judges appointed Ken Feinberg, and why they chose him to begin with, I don't know, but they chose him as a special master to create a method of resolving these cases. I recently read an interview with Feinberg in which he said that the first time the judge called him and said, "I'd like you to mediate these disputes," Feinberg said, "I never took a course in mediation. I don't know anything about mediation." And the judge said, "You're smart. You know what you're doing. People will respect you. You're who I want." Well, having taught mediation for a number of years and having trained mediators, I would like to think that people who are going to do mediation, in fact, did take a course in mediation and do know something about mediation. But the reality is that Feinberg devised a system to resolve those disputes. And much of what he did, and he is the primary character portrayed in the movie Worth, primarily what he did was to create matrices. And I suspect it was something like what the workers' comp system does, where he said, these kind of injuries, these kind of results, this kind of effect on the rest of your life, this is affecting your employment ability, this is the kind of money you were making, here's your figure. So objective, cold, calculating CPA type work. So how old were you? What kind of job were you doing? How much money were you earning? How has the injury affected you for the rest of life? What kind of damages have you already suffered? What kind of medical cost? Here's a number. And it worked. And a lot of cases got resolved. So now we have 9/11. And Feinberg, and by the way, if you've watched the movie, and I'm not going to give away all of the movie, I think, is very true to life. I know a lot about how Feinberg handled this issue. I've read a lot about the processes, and much of the movie, I can't think of anything in the movie that I think is untrue, with one exception that I'll tell you about in just a second. In many cases, the people he's dealing with are a conglomerate of several people, but the issues that they raise, I think, are pretty true to life. So here's the one time where I think the movie distorts what I understand to be the truth. So 9/11, within days of 9/11, the airline industry went to Congress and said, you have got to give us immunity from suit. And Congress began working on that issue for the airlines. And then somebody said, wait a minute, if we're going to give this kind of relief to the airlines, shouldn't we do something about the people that got hurt? The movie would suggest that they happened simultaneously. My read of the situation is that the victims was sort of an afterthought. Regardless, Congress created a 9/11 victim compensation fund and told John Ashcroft, then the Attorney General, choose a master and let the master create the rules and just run with it. And again, as I understand the life, it was Ashcroft that reached out to Feinberg. In the movie, Feinberg's reaching out to Ashcroft. Regardless, they got together and Feinberg became the master. So somebody asked me before, what kind of rules were there? How would you choose? There weren't any rules. Feinberg was going to create the rules. So he was given an open book. Just do this, take care of this, provide some compensation. And if you watch the movie, or if you've heard anything, to a large extent, Feinberg started using that same approach. Where were you working? What kind of money were you making? What was your projected life history? What kind of dependents do you have who were dependent upon your income that they won't have because you've been killed? Here's a figure. Would you like the money? There is a scene in which Feinberg is talking, in the movie, there's a scene in which Feinberg is talking to a group of people. And he says to them, I'm the only game in town. And that does not go over very well. That, I believe, is a true scene. I'm told that in the early days, Feinberg went out, talked to victims groups, tried to recruit them into this program, and said things like, I'm the only game in town. Let me explain why he said that, and then I'll explain why it didn't go over very well. He was the only game in town, and here's what. The people that killed their loved ones are dead. They were the pilots. They're dead. The people that plotted the attack and funded the attack are way away, thousands of miles away, if we know who they are. But we know that they're thousands of miles away. So who are you going to sue? Well, some people said the airline industry knew that this was a possibility. They did not have adequate security at the airports. We ought to be able to sue the airports and the airport security systems. Well, they're getting immunity from Congress. And it would be hard to show that the security at the airports, which the pre-TSA days were pretty lax, that they really should have anticipated this. Well, who else could we sue? Well, if you were in the towers, there are some people that said the towers had never had adequate evacuation systems. They knew that the elevators and their PA systems were not up to par. We could sue them. Well, some of them are dead, but the people that own the towers, they're still around. Can you make that lawsuit? Maybe. So what Feinberg was trying to say to these folks was, the people you want to sue are dead, or they're miles away, or it's very iffy that you could make a case. And at any rate, it's going to take a whole long time and cost a whole lot of money. In the meantime, you need to pay the mortgage. You need to put food on the table. You need to plan for college for your kids, et cetera, et cetera. That's what he was trying to say. Not very artfully. And the response to the folks, the response from the folks to his statement, I'm the only game in town, reflected how coldly they heard that statement. And that takes us back to Owen Fisz's statement. Is the purpose of justice system just to give you money if you've had a loss in the shortest amount of time with the least amount of energy and the least amount of cost, or is it something else? Is it to give effect to these great values that we stand for, this justice? How do you get justice in a case like 9/11? And in the end, Feinberg will tell you that he is absolutely convinced that no person to whom he gave money, awarded money, and the money was from the federal government, believes that it was justice. But he will also tell you that they were able to make the mortgage and pay the rent and put money on the table. So if you watch the movie, you realize that at a certain point, he stops being this cold, calculating CPA and starts listening to people. One of the things that I have found through the research that I have done in the mediation field is that people like mediation. Even when they lose, they like mediation. And one of the reasons they tell you they like mediation is they had a chance to be heard. I don't know that there's any research yet on problem-solving courts, but I'm going to bet you that part of the research on problem-solving courts is going to be somebody listened to me. They treated me with respect. They no longer considered me as just a number, another prisoner, another veteran who couldn't get his life together. They treated me as somebody who was suffering and had problems. And they did not just move me from one courthouse to another. They actually sat down and said, Let's get to the problem and let's see what we can do about it. If you talk to people in the medical field, you'll frequently hear people say, well, the most important thing in life is health. I disagree with them. I think the most important thing in life is being respected. Maybe I'm being a little too philosophical, but I think that you see people whose health is terrible, but they feel respected. So they feel that they're treated with respect and they're enjoying life to the extent that they can enjoy life, whatever the disability might be or the health situation might be. I think it's that being listened to that gives us respect, and that you see in mediation, and that I think you finally saw Feinberg and his team do in the case of 9/11 victims. I want to have a few closing comments to make here. We're nearing the end, but I want to give you a chance, if you watched Worth, to weigh in on any questions that you might have about Worth or any comments that you might have. How is it that we value life? How is it that we value the harm that's been done to you in cases where you did not lose your life, we hope, but you were harmed in some way, such as through this car accident? So any questions, if you saw the movie, or any questions about anything I've just been talking about? So I've just gone through, by my count, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 alternatives to the civil justice system, the civil trial system. Not all of them work in every case. None of them is perfect. Not all of them are feasible, economically feasible, but there are alternatives. And as we're sitting here this morning, I guarantee you somebody somewhere is thinking of another alternative. Well, RJ points out to me something that is extremely important and brings us back to cold, hard reality. And that is, in a case like AT&T, DirecTV, Dish, consumer matters like that, what's the alternative? So if the alternative is, if we threw out those one-sided agreements that I don't like, and we said, DirecTV, you can't have a dispute resolution clause that says you'll arbitrate, then what's my alternative? Well, my alternative is to go to the courthouse to get what? $9.50, $99, $300. You know, it's not very cost effective. I could go to small claims court. Me and AT&T, who do you think is going to win? Frequently, it might be more. It might approach thousands of dollars, but it's not going to be sufficient to hire an attorney. If I called an attorney in town and said, would you handle this small claims court matter? I'm suing AT&T for $5,000. They would say, we're busy that day. So yeah, the cold hard reality is it's very hard in a consumer case because of the cost. That's one of the reasons, by the way, that mediation worked in small claims court, where my students used to go, with local merchants. It's not going to work with AT&T or DirecTV, but it worked with local merchants for whom there had been a dispute, and you could work it out because they're local and they care. Or at least they can do a cost-benefit analysis and figure out that it's cheaper to resolve it than it is to keep fighting. But it's not going to work with a major consumer groups like DirecTV and so on. The turning point in the movie Worth was when Feinberg listened to people instead of having his associates listen. So listening and respect goes both ways. I would agree. Okay, so we have in this country, thanks to the common law from I'm forgetting the date, 13th century England. And thanks to the US Constitution and the Illinois Constitution, we have a system that gives us remedies in cases like a car accident and gives us a jury trial system. And I should have mentioned, of course, you could elect for a bench trial instead of a jury trial, which in many cases might be more cost effective. Cost effective because you don't need as much lawyer time for a bench trial as for a jury trial. But we've seen that it's not perfect. We've seen that it could provide us with relief in a case like this. It would take us some time, it would cost some money, and it would be emotionally draining. We've also seen that there are alternatives now. And we're left then with those two questions. I'm going to go back to them. So, do we want systems that are shortest possible time, least possible expense, minimum stress, that provides us with justice? But keep in mind this word healer. So we can't heal everything, but will this system heal the injustice? Or are there times and places where there are values so important that settlement is not it? That prisoner example, I think, is such a good example. That prisoner who did not suffer any out-of-pocket cost, but suffered an insult to his dignity and some pain, and he wanted to be able to be heard, to be listened to. And are there times when settlement is not going to be the solution? We really need that court process or some other process that allows us to give effect, give interpretation, give dose of reality to those very important values embedded in our Constitution. One last example, and then I will stop. Some years ago, a woman sued in federal court because she had been sexually harassed. At that time, there was no recognition in the law for sexual harassment. Just didn't exist as far as the courts were concerned. Had she settled her dispute, which she could have done with her employer, we might not have today an area of law called sexual harassment where you could sue and have your dignity restored and be compensated for injuries that you suffered, not maybe physical injuries, but emotional injuries, maybe injuries to your paycheck, to have injuries resolved because of the harassment that she suffered. There was a case, I expect, that he did not want to settle, he wanted to take to court. Or let me give you another example. We have in the United States something called the Family and Medical Leave Act, which allows you to take leave if you have someone in your family who's ill. And let's say that you ask for a leave and your employer says, no, can't, it's bad time, can't take it. I don't care what the feds say, can't do it. You could settle that probably after the fact for some amount of money, but it's not going to make up for the fact that during that time that your loved one needed you, you weren't able to take off. So maybe you want to set the tone for the future, and maybe you do want to sue and create more law and create more precedent. One last thought about all this. One of the things that the jury trial gives us is a sense of the value of a case. If everything's going to be settled or done by arbitration or mediation behind closed doors, how are we going to know the value of a case? So if, for example, for the next 5 years, there were no cases tried in Jackson County, they all settled, how are we going to know how a jury would assess a case in Jackson County? How would attorneys 5 years from now update their understanding of the value of a case if there weren't any jury trials. I'm not suggesting that we need all jury trials. I am suggesting there's a time and place for them. And I'm suggesting there's a time and place for these alternatives. And I will leave you to pursue some more of those two questions. What's the value of the criminal justice system? Or the civil justice system, rather. We could do the same thing with the criminal justice system, but you're going to need a different teacher for that. So what's the value of the civil justice system, our trial system? Important enough that our founders put it in the US Constitution. What's the value of these alternatives that are less costly? And I'll leave you to decide what justice is, and I'll leave you to decide what's the value of a worth of a human life. And I encourage you to watch the movie if you haven't done so. So with that, thank you all very much, and we are done. Take care.
Thank you.
Thanks, Suzanne.